Hi, I'm Velshi with MSNBC. On the heels of mass shootings in Buffalo, Uvalde, and Tulsa, the Supreme Court is expected to make a decision any day now in a closely watched Second Amendment case. Joining me for a more perfect union is Jeffrey Rosen, the president and the CEO of the National Constitution Center. Jeff, this particular lawsuit challenges New York's restriction of concealed carry permits. But tell us, under the Constitution, how are Congress and the states allowed to regulate guns, and what could the outcome of this case mean for gun regulation in America?
Well, Ali, to answer that question, we've got to go back to a 2008 Supreme Court decision called District of Columbia versus Heller. And in that decision, Justice Antonin Scalia wrote for the court that the Second Amendment does protect an individual right to own arms, but like most rights, the right is not unlimited. And then Justice Scalia listed a series of categories where gun control regulation might be constitutional. And here's his specific language. He referred to prohibitions on carrying concealed weapons, prohibitions on the possession of firearms by felons and the mentally ill, laws forbidding the carrying of firearms in sensitive places like schools and government buildings, laws imposing conditions and qualifications on the commercial sale of arms, and laws prohibiting the carrying of dangerous and unusual weapons. So let's think about those last two categories, because that's relevant for the two big regulations that President Biden has proposed in light of the mass shootings in Texas and Oklahoma and Buffalo, namely assault weapons bans and background checks expansion. There's not too much doubt that background checks are consistent with Justice Scalia's categories. He says that laws imposing conditions on the qualification and sale of arms are okay. But what about assault weapons bans? That's the big question. Now, Congress passed an assault weapons ban in 1994, but it expired in 2004. Currently, 7 states plus the District of Columbia ban assault weapons, including California, Connecticut, Hawaii, Maryland, Massachusetts, New York. And the question is, are those consistent with the Second Amendment? Now, you'd think that they might be, because Justice Scalia said that laws prohibiting the carrying of dangerous and unusual weapons are constitutional. But earlier this month, the Ninth Circuit blocked a California law banning those under 21 from buying semi-automatic assault weapons. It was a 2-to-1 decision, and the court found that young adults have an equal right to bear assault weapons as adults above the age of 21. And here's the crucial language. The court said America wouldn't exist without the heroism of young adults who fought and died in our Revolutionary Army. Today, we reaffirm our Constitution still protects the right that enabled their sacrifice, the right of young adults to keep and bear arms. Ali, that decision may be a complete outlier. Other federal courts have not struck down bans on assault weapons, but this is the huge question, and we'll know more about what this Supreme Court would say about assault weapons bans later this month, as you said, when the court's likely to decide this challenge to a New York law requiring a special reason to have a concealed carry permit, which is currently pending before the court. So that's the lay of the land. It would be great for viewers to check out the Heller decision, read Justice Scalia's categories, then read the briefs in the assault weapons case, and of course, read that Supreme Court decision once it comes out later this month.
Let me ask you one extra question, because you and I often talk about Supreme Court cases that are dealing with contemporary issues. In this particular case, with the rash of mass shootings that we've had, particularly with AR-15 type weapons, does any of that, does the coverage, does the fact that it's in the zeitgeist influence how the court may decide, or do they deliberately stay away from that kind of thing?
Well, it depends on the justices. Some of the justices, led by Justices Thomas and Gorsuch, say we should never look at the zeitgeist, only look at the original understanding of the Constitution, and it's the court's job to ignore public opinion. Other more pragmatic justices, like Justice Breyer and even Chief Justice Roberts, do think it's relevant. And basically, though, everyone agrees the founders never thought about assault weapons. So it's an exercise in constitutional translation, how to translate the principles of the founding in light of new technologies to decide whether assault weapons are dangerous and unusual weapons. And the truth is, there's no clear answer to that question, either from text, history, or structure, which is why the court's likely to divide on tough questions like this.
Jeff, thank you as always. Jeffrey Rosen is the president and the CEO of the National Constitution Center. Be sure to follow Jeff and the National Constitution Center on Twitter @RosenJeffrey and @ConstitutionCTR.